Our next speaker is Scott Turton, practices in Toronto, is a sole practitioner in the British barrister mold, and will speak to us on non-compensatory damages.
There are three categories of damages that have been referred to in the title for this paper. One is nominal, one is liquidated, and the other is exemplary or punitive. And I should tell you at the outset that exemplary and punitive are just interchangeable words for the same thing. But it's to be remembered that the context of this course today is maximizing damages in commercial cases. And I can tell you that when we look at the three categories of non-compensatory damages, nominal, liquidated, and punitive, in my opinion, only one of those is really of very much use to today's practitioner in upping a damage award, and that's punitive damages. But I'm going to remark briefly on nominal and liquidated damages within the modern context, although it's my submission that they don't have a great deal of application today. Now, nominal damages are precisely what they say. They are damages in name only. They're not based on compensation. And the reason that nominal damages usually arise is because either there is no true damage sustained, or else because the damages are incapable of calculation within the normal compensatory mode of calculating damages. So the court, feeling that a wrong has been done, but being unable to put a finger on its damages, as it were, grants nominal damages. And the utility of that concept, I'm sure you can all measure for yourself by considering the number of times in your own experience that you have successfully recovered an award for nominal damages. I, for one, have never run across it in practice, but it's out there. And for all those of you who are interested in gaining damages of $1, you may wish to include that in your pleadings. Now, the next category is liquidated damages. And it's generally considered to be part of this overall concept of non-compensatory damages. And in the case of liquidated damages, I myself would not classify them as non-compensatory damages. I would say that it is a breed of damages which is not based strictly on normal compensatory principles. In practice, you will find that liquidated damages occur at trial most commonly in situations of a clause in a contract which stipulates that damages will run so many dollars per day in the event of delay in performance or delay in the completion of a contract. You'll see them in construction contracts. You'll also see them in contracts for the purchase of things. I can think of one with General Electric, which didn't go to trial, which involved the purchase of an icebreaker. So in a situation like that, you'll see them. But here's the practical problem you run into. The fundamental roadblock which is raised on liquidated damages is that phrase you'll all remember from law school: to be enforceable, they must be a genuine pre-estimate of damages, as opposed to a sum fixed in terrorem. Now, when you're at trial and you're the plaintiff and the defendant raises that and says this liquidated damage provision in the contract is not a genuine pre-estimate of damages, how are you going to deal with that as a plaintiff? The only practical way that you can deal with it is by demonstrating to a court what the actual damages are, and then showing that they're not far off what the liquidated damages are. Because the case law gives you a pretty fair indication that if your actual damages are $10 and the liquidated damages are $100,000, the liquidated damage clause is going to be struck down. So again, speaking very practically, when you're faced with a liquidated damages clause in a contract and you have to decide how you're going to take that case to trial, if you do not prepare damages in the ordinary way as well, you are going to run a very, very serious risk if a court decides that the cause is not a genuine pre-estimate of damages. You'll find yourself recovering no damages, and then you may have recourse to that very useful concept of nominal damages. So remember, liquidated damages, not that useful in my opinion. Number one, it's primarily an exercise for solicitors drafting contracts, and number two, when you're at trial, you cannot take the risk of relying exclusively on them. But if you can demonstrate that your actual damages approximate the liquidated damages, you may well be able to take advantage of liquidated damages, and you may find that they run at a higher rate than actual damages. So in that way, you can maximize the damage recovery. Now, punitive damages, also called exemplary. Either word is acceptable. In my opinion, there is your useful concept for today. There is your opportunity of increasing the damages. Now, I'll refer you to one very fresh case, and that's the Claiborne Industries and National Bank case by the Court of Appeal. It's reported this year in 1990. In that case, punitive damages were awarded running over $1 million. In fact, the way the Court of Appeal calculated them was on the basis of 70% of all of the other damage awards combined. And because all of the other damage awards ran well over $1 million, you can see that that had the potential and the actuality of being probably the largest punitive damage award by far in Canadian history. Although I should remark that the 70% that is actually fixing punitive damage awards as a given percentage of the compensatory damages was something new, and you won't find that in other cases. It's a good idea potentially, but it's not a well-trodden path. Now, when we talk about punitive damages, I think everyone here probably already has a feel for what they are. They are damages which are awarded because of that sense of, shall we call it, outrage, which is felt by the court or the jury for the conduct of the party. Now, this was an old concept. You can look in the paper I've written about some of my thoughts on just how old it is, but certainly it's a very well-trodden path. And probably it arose because of the fact that courts found it as an effective way of policing behavior. And that is one of the conclusions I'll submit to you today as to why punitive damages have a good future, because they are a very effective way in such a large society as ours of policing private behavior, in particular commercial morality. Now, all that fine history in punitive damages went off the rails when we got to Rooks and Barnard in 1964. That's an English case, and it was a case that essentially tried to restrict and effectively restricted punitive damages to very, very limited applications. And if you look at a book on damages or case law on damages in England today, you'll still find Rooks and Barnard being followed, although often criticized. But this is not the case in Canada, nor is it the case in certain other Commonwealth countries. And you will find, again, if you look at the decisions, let's say, for about the past 10 years on punitive damages, the majority of them have been at the pleading stage. They have dealt with striking out pleadings that have tried to claim punitive damages in breach of contract cases. Now, I believe that that issue has finally been set to rest last year by the Supreme Court of Canada in a case called Vorvis versus Insurance Corporation of British Columbia. It was very appropriately a case dealing with the wrongful dismissal of a solicitor, and the issue was whether or not, aside from compensatory damages, an award could be made for what was called punitive damages. Now, in fact, the damages were not really punitive. They are what are called aggravated damages. There's an extremely, almost academic distinction between aggravated and punitive. You'll find it ably set out in a passage in Professor Wadham's book which you'll find adopted and approved by the Supreme Court of Canada in Vorvis. But essentially the differentiation is both damages look at this high-handed, arrogant, offensive conduct, but aggravated damages are compensatory. They are answering the way in which the wrong was committed, whereas punitive are there not only dealing with the way it was committed, but also a sort of general deterrence concept. And punitive damages are not at all linked to compensation, which is why the court has a completely free hand in the amount they award. Now, one of the big issues up until Vorvis was can you gain punitive damages in breach of contract cases? And in Ontario, you will see decisions at what was then the High Court level going both ways. Yes, you can. No, you can't. Probably the most often quoted decision in favor of allowing them was Mr. Justice Linden's decision in Brown and the Waterloo Police Commissioners, which decision was also approved in Vorvis. And although there is some uncertainty in some areas in Vorvis, in my view, is that reading the case carefully, it does state both the majority and minority positions that you may now claim punitive damages in breach of contract cases. Where the area that's a bit gray comes is that in the majority decision by Mr. Justice McIntyre, he seems to suggest that you cannot have punitive damages for breach of contract unless the conduct that constitutes the breach is in and of itself an actionable wrong. And in one portion of the judgment, he suggests that it must be an actionable tortious wrong, which is the American position in the restatement. Now, in the minority position, Madam Justice Wilson said, no, it's just this straightforward. You can have damages in punitive damages in breach of contract cases. Now, so I think that from a practical point of view, you can go ahead, plead your damages in breach of contract cases. If you want to be absolutely safe, you're better off in tort, or if you've got one of those economic situations where it both sounds in contract and tort, where you can throw in a conspiracy or an inducement to breach of contract case, then you're on very, very sound grounds. As far as punitive damages in tort, no problems there. You've got about 1,500 years of jurisprudence behind you, and perhaps even longer if you go back to Roman times. Now, when are these damages going to be awarded? You will find a consensus of adjectives in the case law. Conduct, shockingly harsh, vindictive, reprehensible, malicious, all sorts of words of opprobrium like that always describe it. But there is no absolute test in any case that says where the line is on what is punitive, what is not punitive. In every case, it's a sense of the trier, that is the judge or the jury, how they feel about the conduct. And if it, because of its nature, warrants that something extra. Now, that's your job as an advocate to put that in front of the court to emphasize why it's not just the ordinary wrongful conduct, because every time you win a damage award, it's because the conduct was wrongful, but there must be some adjective attaching to that wrongful that you've got to demonstrate. And that's something that you should be looking at not as the case goes along. You should be looking at it virtually from the first interview, and I'm going to touch on that before the end of my talk when we talk about what you should put in your pleadings. Now, in looking at the cases, my suggestion to you is that probably these days the most profitable, potentially profitable area for winning punitive damage awards is when you have a defendant who has made an unconscionable use of superior power. And that power can be in many forms. It could be a superior economic power. Remember the concept of inequality of bargaining power. It can be one who uses a position of authority or trust unconscionably. And you will see some of the cases, not at trial, but certainly at the pleading stage, dealing with solicitors, insurance companies who are under duties of good faith. It can even be the unconscionable use of actual physical power. And that could be, for example, in one can think of, there's a case I'm going to talk about by Mr. Justice Galligan, Nantel and Parisienne, in which it was wrongful eviction in a landlord-tenant situation which attracted punitive damages, and it was the physical eviction which was most offensive. Probably one other thing you might consider is there is a well-established line of authority that deals with the fact that if conduct is punished in the criminal courts, you cannot have punitive damages in the civil courts. So that the converse would be that if the conduct is criminal but is not punished in a criminal court, in other words, no charges were ever laid, you might consider raising that as a reason why punitive damages can be awarded. So think in your wrong in terms of it being a criminal wrong if you can. So get a copy of the criminal code. There are lots of commercial crimes in the criminal code. And if you can find that the wrong you're talking about fits within one of those, plead that fact. Let me just talk about a few examples of punitive damage awards, just to give you a feel for the amount. Most of them, unfortunately, have been small. Madam Justice Wilson commented on that in the Supreme Court of Canada in Vorvis, said it was the Canadian experience or tradition that the awards had been relatively modest. As I indicated earlier, that has been broken with by the Claiborne Industries decision in the Court of Appeal, very substantial punitive damages. Court of Appeal in Lister and Dayton Tire awarded somewhat larger punitive damages, $35,000 to one plaintiff, $20,000 to another, but that was in the context of compensatory damage awards of $611,000 and $370,000. So compared to the compensatory damages, the punitive damages were fairly small there. So clearly that 70% concept in Claiborne Industries is one we would all like to achieve. Also, I'll give you an interesting decision by Mr. Justice Galligan, and it's one I really do recommend you reading. I've quoted the provisions of it in the paper, and I'll just read from them. It was dealing with the breach of a lease. The rent was $300 per month, and Justice Galligan awarded $35,000 punitive damages in a case like that. So if you talk about maximizing damages in commercial cases, there's an example that 70% is good, but for Justice Galligan, we were going up to something in the vicinity of 800% of the compensatory damages. And this is what his lordship said. He said, if this court were to sanction the conduct of the defendants by awarding the plaintiff her actual monetary loss plus nominal damages, then in my opinion the law would say to the rich and powerful, do what you like, you will only have to make good the plaintiff's actual financial loss, which compared to your budget is negligible. The law would say to such persons as the defendants trample on the smaller person's rights, the sanction of that trampling will be only a relatively minor part of the cost of doing business. Now, as said, if you're looking for one type of situation where you're likely to increase the possibility of getting punitive damages, it's the kind of situation where Justice Galligan is talking about, that someone, your defendant, is willing to absorb the damages, the compensatory damages, just as a cost of doing business, because he's looking to make so much more out of it. Now, the final area I'm going to talk to you about is pleadings. As I said, most of the cases you will find are dealing with the pleading stage. Can you make this punitive damage claim or not? I think that you won't find as many such cases since Vorvis, because the issue of claiming them in contract cases is probably now put to rest. But a lot of these are because you're adding the claim for punitive damages in the course of a lawsuit. I would suggest that what you do right from the first interview is look at the quality, the character, the color of the wrong that's been committed to your plaintiff. And if you think it's one in which you can reasonably claim punitive damages, put the claim in at the outset. And don't just put in the standard phrase that says the defendant conducted himself in a high-handed manner which should attract the award of punitive damages. do better than that, put in some particulars. And I'll tell you why you should put in some particulars, and it's called discovery. And a perfect example of this was a decision by Master Sandler. It's a recent one in which he said, and you'll find it at page 15 of the paper, Numbered Company and Stone, he held that a plaintiff was entitled to rely on the financial means of the defendant to base its claim for exemplary or punitive damages, and he refused to strike out a paragraph in the statement of claim dealing with those means. The limitation he put on it, and I quote from his decision, this ruling would be applicable in every case where on a reading of the other parts of the plaintiff's claim, it can be said that the plaintiff's claim has a genuine potential for an award of punitive damages, end quote. Now, if you put in your pleading something about the defendant's means, I don't have to tell you all the interesting questions that you can ask. And that is not only interesting in cases of your actual punitive damage claim, but it may well open up avenues that are useful in your compensatory damage claim. So, plead it. One thing also to bear in mind in pleading is don't talk about the defendant in general, talk about him in particular, his conduct relating to your plaintiff. And in this regard, I'll refer you to a decision of Master Pepiot, Curry and Advocate General at 9 CPC 2nd 247, in which Master Pepiot held that punitive damages must be based on conduct of the defendant which affects the plaintiff without taking into account conduct to the world at large. So the moral of that is you can plead that the defendant is rich, you can plead that he's powerful, but don't plead that he's generally an evil person. That will be struck out. So, of the three non-compensatory damages, my conclusion and what I urge is explore the possibilities of punitive damages. The amounts of the awards are opening up in Ontario. I've got one great advantage over compensatory damages. You don't have to call expert witnesses. Generally, you don't have to worry about all those complex calculations of compound interest or anything else. You can deal with some broader categories. You can deal with more emotive categories. It gives you an opportunity to practice pure advocacy and to sway the emotions of the court. We are looking at a situation where if the ever-increasing instance of award of solicitor and client costs is any indication, where courts are far more willing to sanction improper conduct by litigants with awards of money which go beyond merely compensating people. Thank you.
I should have mentioned as I introduced Scott that he played a very active role, a very helpful role in the planning committee that led to today's activities. For our next paper, we cast about for help in the nuts and bolts and the mechanics of more effectively taking our claim for greater damages from the initial interview on to discovery. We cast about for somebody with a reputation for imagination and innovation. And so often this is found. In southwest Ontario, we see examples of Bunny Wonder, of Cherniak, Mayor Lerner. And today we bring you an exemplar of this in the person of Leon Peroyan.
Thank you very much. You can all relax now because there's not very much of import going to come from me by the way of the law or the substantive issues, because I feel that in those cases we can do our own research. I can hire juniors, and if worst comes to worst, I can hire a professor to do the research for me. But it's the nuts and bolts of everyday practice of what do you do when that client walks in your office and says, I have this problem and it amounts to millions. I guess we had to learn the hard way. We came to some of these lectures when we were younger. We started out a law firm just with a couple of young fellows, and we didn't know very much and don't know a hell of a lot more now, but we learned through our own mistakes and through the benefit of having them corrected in courts and elsewhere and of coming to these lectures. But one of the things that I found that is absolutely important if you're going to do any commercial litigation is to have common sense. That's all I'm going to tell you about. All of you got that. Have a sense of humor. It may come to pass that you will laugh only out of hysteria, but that's better than the alternative. And have a keen sense of dedication to your client, because out of that sense of dedication will come your own reward. One of the most important parts of the whole matter, in my opinion, and everybody says this is the most important part here, and the most important part there, and the pleading is the most important part, and discovery is the most important part. But for me, one of the critical points in preparation for any commercial case is the initial interview. And I really don't care whether that initial interview is 1 or 5 or 7 or 10. However can you develop a fact situation for a client, no matter the law, unless you find out what the facts are. And the facts in a commercial transaction ordinarily aren't limited to, as they are in a motor vehicle accident so often. We were at an intersection, crash, bang, he was going left, I was going right, the light was red, the light was green, he was speeding, she was speeding, whatever the hell happened. In a commercial transaction, it goes far beyond that. And the necessity is to understand not only the organization, not only to understand the immediate problem, but to understand the field itself. You almost have to become an expert in a given field if you're going to do really a good job for your client. And there's no sense in repeating a number of things over and over again as each new person comes into it. So what we try to do, and remember these are my experiences, that doesn't mean they're right. Matter of fact, coming from me, I suggest you might want to think in terms of whether they're right at all. They're just ideas for you to consider. But there are some initial things that we would forget. We all forget. I forget. One in particular is, you know, commercial clients aren't nearly as sophisticated as you think they are. They're business people. They may be experts in labor relations. One may be a tool and die maker. One may be a genius at making money as an entrepreneur. But sit down and talk about a piece of commercial litigation, they're at sea. And so take your time, I suggest to you, and explain to them that which is absolutely rudimentary to you, but which is so very, very important for them to understand what the task is that you're about to embark on. One of the things I think that I always like to make sure that they understand is that this isn't my case. I'm not a plumber, I'm not an electrician, I'm not a chemist, I'm a lawyer. It's their case. Because the commercial client very often will bring you this, if you're lucky, great file, dump it on your desk and say, call me if you need me, but not very often, thank you. Please send a check. Soon. You have to disabuse them of that very quickly. And if you're an older lawyer, and I guess I qualify for that, you have to make them understand that this is not only their case, but that other people are going to be involved in your team with you. And they have to accept that, and there'll be a number of reasons why they will. You have to make them understand, and we'll talk about this a little later, about costs. They don't. And you have to make them understand that because you're a lawyer, you don't know everything about everything, you just sound like you do. And you need an educational program from them. And one of the most delightful experiences I ever had from an education program was when a client in a very large case, well, large for us, anything over $100,000 down Windsor is a hell of a big case. This involved $3.5 million, so we were really into the big stuff, not like you Toronto folks, where all of them are $3.5 million cases, I understand. They're the small ones, the bread and butter cases. But this client actually detailed the vice president who was in charge of the construction of a very significant chemical plant down in our area to the case for 1.5 years. And that client representative brought it to us knowledge that gave rise to our, in essence, cracking the case before we got to trial, because we began slowly, but ultimately fairly well, to understand the intricacies of this chemical process. And the example that came out of it was that we caught the other side absolutely flat-footed in inaccuracies with the greatest of respect I never even anticipated in the beginning, and frankly, if we hadn't had that kind of an experience, never would have had. Never would have seen it. So it's important that you spend a lot of time with it. It's important that they bring to you the kind of educational process I'm speaking about. It's also important in the first interview to talk about those disdainful things, fees. Most of us are so anxious to get on with the file. We're so excited about this great process that we have in Windsor, the $100,000 case, in Toronto, the $5 million case, that we really are reluctant to talk about fees, and we make a mistake there. Talk about them right up front, I say to you. Because the client is as anxious about them, perhaps more so than you are. That client should recognize they're going to pay. That client should also recognize that unbelievably, from their point of view, this simple case, why else would they have brought it to you? This simple case may take a lot of time, and time is money, and they'll have to pay for it. And they should also understand that costs, every client's case is just. They're looking for justice, and justice screams out, as we've heard here today, that they be totally indemnified as to their fees, and after all, you, lawyer, will be paid by the other side, in essence. Along the way, they may help finance it. Disabuse them of that. Give them a primer on the question of costs. Give them a primer on the law of costs as it relates to offers. Make them understand as well that you're a law firm that's, unless you're a lot wealthier than most of the law firms that I know of, most law firms cannot fund these horrendous actions from beginning to end as they used to without some interim billing. At least ours can. And I haven't seen one yet that can. Not with a managing partner that is awake and can count beans, and most of them can. So the result, and if the big firms can't do it, the little firms can do it less. So they've got to understand about interim billing. They've got to understand how you're going to bill. And they've got to understand that the risk for costs is theirs, not yours. Nothing used to frighten me more or upset me more in the odd time when we lost a case and the client said, what the hell, you lost? Just don't have to pay you. Nothing used to upset me more when we won. He said, we won, we were right. Just don't have to pay you. The other side. So you've got to be brutally frank with them. Brutally honest, straight up front, in a pleasant way, of course. And in the final analysis, we produce to them an agreement that says, here's how you'll pay us. And here's when you'll pay us. And here's what we're going to do if you don't pay us. We're going to quit work. That's simple. Unless the client can't afford it. Then we make a fundamental decision as to whether we're going to go on or not. There's nothing worse, in my opinion, than a lawyer or a law firm taking a file, not having addressed the issue of costs, have the client run out of money halfway through, and you say goodbye. That, to me, is professional misconduct. However, if you take the file, and the client does abide by his obligations, which he's agreed to, or he or she have agreed to, or the corporation's agreed to, and there's an understanding that they've only got limited resources, and at the end of the day they run out of those resources, and you've made the commitment, then you stay. Because, it's good for two people. One, it's mandatory from a professional point of view that we do this from time to time. From a social point of view, in my opinion. But secondly, it's also mandatory from your own point of view. If the other side ever finds out that you can be run out of money, they will use that weapon against you often. I make absolutely certain that once we take that file, that other side will never run us out of money. I had a case one time with a very major railway, and one of their very unctuous senior counsel from Toronto, of course, he said to me, well, Mr. Perroy, this was about the 5th year of this little fight between the railway, who wanted to put in an 8,000-foot siding on either side of the main line, between two lovely residential areas, one which was traditionally the other side of the tracks and the other very fashionable. Two neighborhoods come together, hire a little fat man down in Windsor, give him a hand, and we had at it, and we had won some, lost some, but there were no trains on these tracks for forever, really. But the fight went on for about 15 years before we solved it, 12 years. But about the 6th or 7th year, I was in the Federal Court of Appeal being abused, and this gentleman said to me, "Tell me, Brian, when will you run out of retainer?" I said, "Run out of retainer? You mean money?" He said, "Yes." I said, "Hell, we ran out of that about 4 years ago." I said, "What are you asking me when we'll quit?" Let me put it to you this way, sir. I'm getting older. But so long as I'm alive and my name is associated with that law firm, we'll fight you. If I'm gone and young Colati, who was then about 2 years out of law school, is alive and associated with the law firm, he'll fight you. And should it come to pass that both of us are gone and this law firm doesn't have our names on it, and one of us had kids that went to law school, they'll fight you. About 13 years, 12 years after it started, they recognized exactly what I meant, and we settled the case very fairly, and I might want to tell you that we got paid. It's not by the clients, but by the railway. So, from the question of fees, you've got to be brutally honest with yourself, brutally honest with your client, brutally honest with your management committee, and be prepared to take the hit if it comes. Now, it's one of the, and I don't want to make a brief here for contingent fees, but I think we're getting to it. We're the only province in the country now that doesn't have some format for contingent fees. And I think that the time has come, as the cases become more and more expensive, that someone look at the propriety of, from an access to justice point of view, of having contingent fees, so that we know at some point we're going to be paid if we're successful. The other thing you should also recognize, in my opinion, that there are times when we're reluctant, you know, as lawyers, and we don't want to talk about this out loud, that we want a premium bill. There's nothing wrong with talking about premium billing. It's not indecent. It's not illegal. But talk to your client about it right up front. And if we should be successful, having carried your file, what we will do is we will premium bill you on this basis. If they tax it, they tax it. I think that now I'm seeing this, forgive me, the old fellows say taxing, the new folks say assessment officer, it's the same thing. If they assess it, be your obligation to demonstrate why, and I think I'm seeing reports now that assessment officers are finding that that sort of an arrangement is acceptable. I cannot stress, under the topic of facts, too strongly the necessity of your finding out immediately what immediate problems you have. Are there time limitations running against you, for example? It's nice to find out who's on the other side and what kind of people are on the other side. Some of you went to the University of Windsor, and Dr. Ianni, who is an Italian by background, says that the Southern Italians pray for intelligent enemies. Well, I think that all lawyers ought to utter that prayer too, because if you've got a responsible and strong and intelligent opponent, a resolution usually is a lot easier to reach earlier on than someone who has decided that they're going to waste or spend an enormous amount of their client's money. I think that the facts, you'll go back over them in different ways, but all of your people in the group, in your team, should be aware of them early on, and they should explore them together. Production. Production's a funny thing with most clients. They don't seem to understand they've got to give up their documents, and they hoard them and they pass them out to you like they're trump cards in a game of euchre every once in a while, you know, and you can't have that. You got to tell them straight up front, now's the time, we want them. If we don't get them, it's going to cost you more money, and eventually you're going to end up in difficulty with your law action. It's obligatory to have them, let's have them now. And when you get them now, being early, you can put together a team to respond to the necessity of reading those documents. I have a lot of problems with production, personally. I don't mind our people listing them, and I don't mind our people organizing them. However, I have a very great concern personally about not reading every piece of paper. As I get older, my memory starts to fail me. And I find that with a failing memory, or any other kind of memory, having read it myself, notwithstanding the fact that we have now such enormously sophisticated devices that I can say a phrase and my people can flash it up on a screen in about 3 seconds and give me the document probably 15 seconds or 30 seconds. Notwithstanding that, I have great comfort in reading every document. One of the cases they were telling you about, there was a reference made to a another case, Raymond was involved, and there was a reference made to a report. There was a building case where Ministry of the Environment had gone in and dug an enormous sewage, put in enormous sewage works, and they built a great pumping station next to a piece of property that our client eventually bought, and the house subsided in it as it was being built, after it was built. And nobody would ever fess up to what happened. It was actually a trespass. But we could never find out what happened at the time of construction, except there was this oblique reference to a report from an engineer. Well, we asked for it. It made our case, because they had gotten a report, and he had at the time outlined the potential in the future for precisely what happening. It gave rise to our being able to settle the case. So I tend to be an old-fashioned fellow, and I read all or most of them. A chemical case I was telling you about had about 250,000 pieces of paper, and I think I said several. I think there were about 8 or 10 5-door filing cabinets, and when the file moved, the client would call a trucking company and say, "Take the file from here to there." Off it come. We tried to accommodate by moving to the client from time to time and working out of their office. You'll also get into a great discussion with the client of this is absolutely confidential. It may be. You'll have to address that with them. You'll have to sit down and discuss how you can best handle it. Contractors are the notable example who are very, very concerned about making available their bid documents, their pre-bid quotations in their office. And if you've ever watched them make one, you can understand why that's confidential, because in the final analysis it gets down to the chief executive officer of the company saying, "Put 5% on that." And his vice president saying, "We'll never get it. Put 3% on that." Well, we better add 100,000 here, and there's no scientific method after they've got all the papers down there. Somebody plugs in a figure at the end. But there is a format on how they've operated to get their price to a given place, and they don't want to share that with anybody. Different companies use different methods of costing, and they use different methods of being able to bring together a bid, and they don't want to share that with their competition, and so they're very anxious about it. You may want to sit down and talk to them very carefully about that. I'm not going to get through this whole paper. I don't commend it to you for reading except for comic relief at some stage or another. But one of the things that I'd like to take you through, because many of the things on getting ready for examinations for discovery have been said and are really common sense. But one of the things that doesn't get very often said is, what about the client's goals? What's his client want? Want money back? Want restitution? Want damages? Want back their property? Identify that. And beware of the client, in my opinion, who wants to create mayhem on the other side, who wants no more than to use your services for wreaking havoc on the other side because they're competitors, perhaps they're former employees, and the real purpose for their hiring you isn't the recovery of money, isn't the traditional remedies that we seek, but is to raise hell, havoc, and disaster for the other side. If that's the case, you might very well want to think about asking that client to take that file out of the office, because I've never found those cases to be very satisfactory. I think you owe the client a major, today with the cost of legal services as they are, and the concern that everyone, clients particularly, have for the bottom line, of sitting down and looking at the cost benefit of each step you take. I know we all like to take those lovely motions, and motion the other side to hell, into the ground, because they'll eventually find out how good we are. But I think that is an enormous cost. There's an enormous cost associated with it. I think you owe it to your client to sit down and say, here's the cost of this, here's the potential benefit for it, should we do it or not? Now, by and large, I think the client will make an intelligent decision. However, if it comes to the point where the client doesn't want to go ahead and you feel it should be done, then I submit to you that you have to do it. I'm very strong on that. If it should be done, do it even if you're not going to get paid for it. Even if there's a potential you're not going to get paid for it. But don't ask your client to pay for it if they have not even had an opportunity of addressing it. And remember, they don't know what you're talking about when you say, I'm going to bring on a motion to compel this or that or something else. Sit down with them and talk to them about it so that they will have some insights into what you're about to do. In the case that it's always nice to tell good war stories, isn't it? I'll give you a couple of examples of looking at goals, for example. I had a client, at one point, a farmer, so-called unsophisticated fellow, you know, who had a farm that he shared the common boundary line with an airport that seemed to be giving him no end of problem. And we were talking about getting an injunction, you know, to restrain aircraft from flying over his property, making those obscene gestures to he and his family, and suing them for damages and all those nice things. And he said to me in a very practical sense, "How much is an injunction going to cost, Mr. Proy?" And I looked at it, it's about 15, 20 grand. He said, "You know, I think I can build one for less." I said, "Sir?" He said, "I'm going to build a silo right at the end of that runway, 78 feet high. And he said, when I build it, I don't think they'll be able to take off very many airplanes." So he built the silo right at the end of the runway for $16,000, a lot more effective injunction than I could have gotten for him, because it eventually stopped the airport almost cold in its tracks. I think they could take out those little airplanes that go around with radio beams, but that was about the size of it. And it eventually got to be a very, very major problem for the municipality that owned the airport. We finally got down to talking. Even the federal and provincial government were involved in that when we got talking with them too. Somebody finally came to the party with money and we got it resolved. In the meantime, it took about 4 years, he took that silo, filled it up with his corn, fed it to his hogs, and made a profit. So he took a legal problem with a great cost to himself and turned it into a real asset. By the way, he got paid for it when they tore it down, after he sold him the farm and the settlement. So it's something that you've got to think about. Anymore in our office, the young folks are all a lot smarter than I am. I'm here to tell you they are. But they call me into it because they ask me to look at that sort of thing. They ask me to look for why is something not seem right to them and how can we get it addressed. The case with the chemical plant, the story was the chemical plant could sell everything it made. Its sales fell short. Sales fell short because we, of course, had botched the construction of the plant and they couldn't get the stuff up. But something was awry, and we kept looking, and I finally got down to the formula of how you make this stuff and realized there was an absolute lockstep process correlation between the use of hydro and salt in production. Found out that they didn't have any inventory facility there. And so we carried out an investigation through our auditor, our accountants who went in as forensic experts, and we hired them during the discovery process. And when we did, they did a few investigations that absolutely blew the wheels right off the other side, because they found that where they were inventorying this stuff was in boxcars. They couldn't inventory it anywhere else, so they hadn't sold it. What they would do is load up the boxcar and send it somewhere. Some of them had had material in them for 9 months, rather than 2 days, 3 days. Once we found that, we were able to demonstrate pretty clearly that their statement that they had all of their products sold was an absolute untruth, and that their whole case then started to crumble under them. Well, we wouldn't have done that, we wouldn't have been able to do that or foresee that if we hadn't had the help of the client who gave us that factual material, and we hadn't had a guy like myself who's not very smart, so I asked lots of questions, and I had him draw out the plant for me in a very, very small conceptual places that I could see what the process was. And that was very, very helpful to us. In that same case, reading all of the documents, as I was saying a minute ago, was very helpful because there was a fire in one of the dryers and they sued us, the contractor, for it. Fair enough. When we were reading the documents, I saw a reference to an insurance claim, and it didn't say what. I followed that up through the discovery and found out they'd made a claim against their insurers for exactly the same fire and exactly the same damage, and they collected. A little later down the road, I found that there was a claim made by the same company against their engineers for the same fire, and they collected on that one. And I thought that they shouldn't collect from us because, you know, I think twice is enough. And so it was that kind of detail in the facts and through the discovery process that was so very, very important to us. And I can't stress initial interview too strongly, preparation too strongly, discovery too strongly, but you can't go to discovery unless you've had the production and the help from your client to know where the minefields are. Again, I repeat, keep a keen sense of humor. I know a lot of law firms that say, you know, you're not aggressive enough if you're laughing. I don't believe that. And I submit to you that common sense, being conscientious, and being decent to yourself and your clients will get you through the very tedious parts of these cases, getting them ready for trial. Thank you very much.
Ladies and gentlemen, our next speaker is Joyce Harris of the Porter, Poslins and Harris firm in Toronto. She's a specialist in civil litigation, need it be said. She's in great demand as a speaker at functions like this. You'll see why in a second.
That was a little too abrupt. Sorry. The organizers of this program lured you in with a preliminary brochure that explained to you their brief that we as counsel are falling down in the job because we're devoting inadequate attention to the damage part of our claim. And when I thought about it, I thought, mea culpa, I am guilty as well. I started reading cases on damages to prepare this paper and this presentation for you, and I saw that I could spread the blame a little bit. I realized that the reported cases are also devoting inadequate or confusing or contradictory attention to the issues of damages. And then when I thought a little bit more, I thought about why that might be so. After all, we as counsel and the courts have a symbiotic relationship. They depend on us to educate and instruct them, the judges, and when we are falling down on the job because we are not properly educated and instructed ourselves, we're not persuasive enough, and we fail to give them the ammunition they need, those judges, to do a good job in damage calculations. And then I thought a little bit more, and I realized that in commercial litigation, the reason why we are often ill-equipped to present our damage claim is because we don't learn about dollars and cents at law school. We learn about the liability issues, but we very rarely pay, in law school, at least when I went to law school, paid much attention to the issues of damages or the issues of costs. It wasn't until we met real-life clients that we became aware that to them, the dollars and cents, the bottom line, how much, those are the important issues of a lawsuit. And at law school as well, we did not get any grounding in the rather sophisticated accounting and even actuarial principles that are at the foundation of a lot of quantification problems in commercial litigation. If your law school education was like mine, you had maybe one very perfunctory course in accounting from which I learned what a balance sheet was, but certainly not how to read financial statements, let alone how to deal with concepts like business valuations, which are a field for experts. And so the first tip that I give you in my paper, and by the way, these are not, earth-shattering tips. They're little weeny tips, some of which I picked up through 15 years of practice, and others of which I picked up from the cases that I read and articles that I read, and just thinking about the problem and why we're having trouble with it. So the first tip that I give you is to hire an expert, the forensic accountant. Now, when I started practicing 15 years ago, this was almost unheard of as a specialty, but now it's very trendy among accountants, and all of the big firms have a division that specializes in helping you present your economic damages, and at least one firm does nothing but that sort of work. And that little boutique firm, as I call it in my paper, Baron, Blutt and Rosen, has its two senior partners who have done our profession really the favor of presenting the only text that I'm aware of on the subject. Baron, Blutt and Rosen's book is called Litigation Accounting, Quantifying Economic Damages. And I commend it to you to read. Now, don't get discouraged when you start reading it, because about 3/4 of the book is devoted to quantifying personal injury cases. And if you, like me, are dealing in commercial litigation, you have to sort of slog through to the back and about the last quarter deals with different kinds of commercial scenarios that give rise to business losses, and shows you how you can be rather, or they can be rather creative in analyzing and quantifying your client's real-life scenario. They also do you the favor of explaining the jargon of their trade in comprehensible terms so that you can use it to the judge and make it comprehensible to him. Now, Mr. Bristow, who speaks next, I believe, will be telling you how to find a good forensic accountant. So I will not deal with that, although I do mention some hints in my paper. But one thing I would recommend to you is that you get the fellow, and as I point out in my paper, I say fellow on purpose because I've hardly ever, I think one female forensic accountant I've met in my years. They're mostly men, as commercial litigation has until recently been much of a male preserve. At any rate, this fellow that you're going to hire, you should hire him at the earliest possible opportunity. And you will find that it's not hard to sell to your client. For example, you can say to your client, now it's going to cost you a minimum of $10,000, but this fellow is going to help me sell your $3.5, to borrow Mr. Peroyan's figures, $3.5 million claim to the judge much better than I could do it on my own. That $10,000 for the preliminary kind of look-see, and that's about all you're going to get for $10,000 with at least the Toronto forensic accountants, will be considered by your client money well spent, as opposed to the case in which you say, now I want to spend $10,000 of your money getting Professor X at the law school to do a paper for me on, oh, say, Rivtow Marine updated. Are there damages for economic losses in the absence of physical damage? Client looks at you like, who cares? Clients don't care about you making your name for inventive causes of action. They care, and I can't emphasize it enough, much about the issue of how much. And the forensic accountant will help you make the how much a lot bigger than you could do it on your own. And he will help you at every stage of the action, from the drafting of the demand letter to the putting out the heads of damage in your prayer for relief, or what used to be called the prayer for relief and the statement of claim. He will help you wade through the productions, and even more important, the missing productions. He will be more alert than you to what kind of documents should be produced, what kind of documents on accounting and dollars and cents should the opposite party have kept, so that you'll be able to see if you have full production. He will help you plan your questions for the examination for discovery. He will help you analyze the expert's report from the other side and prepare for cross-examination, a brilliant cross-examination of the opposing expert. And he will even show you how to lead him through his credentials and explain his evidence plausibly to the judge. I noted, by the way, I didn't hear, was Mr. Justice Rosenberg here already? I didn't hear him, but I read his paper, and he says actuarial evidence, at least he said in his paper. It's very hard to understand, and he suggests it's a little boring. And so you often see the judge order a reference on accounting evidence, and we hear this all the time. Judges don't like to get into accounting evidence. But these guys, these forensic accountants, believe it or not, they are not boring. Some of them are really interesting, and they will help you to get to know them and show you how to make them interesting to a judge. Another tip. Perhaps you can take advantage of the discrepancy, the contradictory cases on standard of proof required of a plaintiff in proving damages. The strict rule is the plaintiff has to prove his damages like he has to prove almost everything else. A reasonable preponderance of credible evidence, i.e. the balance of probabilities. That's what the Court of Appeal said in 100 Main Street, which is quoted and cited in my paper. But some of the cases, like the Aqua Taxi case and the Multi-Malls case, are a little more lenient on the plaintiff. And you should start thinking in your own mind along the lines set out in those cases, and you should start from the beginning educating the judge to that end. For example, in Multi-Malls, which is a commercial litigation case, a commercial land contract, the judge said that the fact that damages are difficult to assess to the point where they're little better than a guess does not relieve the wrongdoer from paying them. So you should start explaining to the judge that his task in assessing damages may be different than his task in assessing liability. In liability, he's finding facts that happened in the past, and that's all right for the balance of probabilities. But in cases like multi-malls and many pieces of commercial litigation, he is conjecturing what would happen, what would have happened in the future. What if, but for the wrongdoer's default? And so right from your pleadings, you will want to be talking about this kind of conjectural evidence that you may be forced to lead on damages. Now, you may go too far. You may go as far as the plaintiffs in the two cases on damages cited in my paper, which came to the Court of Appeal of Ontario within months of each other, McLean and Vickers, and Friedoff and Pomelift. In both those cases, the Court of Appeal sent the matter back, affirming liability, but sent the matter back for a reference on damages. And in the Court of Appeal case, the courts deplored the fact that it could not fix damages itself because of the meager and unsatisfactory evidence led on behalf of the plaintiff. Now, we as plaintiffs' counsel will not win favor with clients or potential clients if the kind of evidence that we're leading is characterized as meager and unsatisfactory. Nor will we win friends among potential clients or past clients if we have to tell the client at the end of the trial on liability and damages and going to the Court of Appeal on both issues, they have won the Pyrrhic victory of being sent back for another trial on the critical issue of how much, that is the reference on damages. And we will win even fewer friends and perhaps lose a negligence suit if these clients are aware of the American statistics, which I cite in my paper, that this is an astounding statistic to me, and I don't know if it's applicable to Canada, but I don't see at first blush why it should not be, that plaintiffs in trials on liability and damages combined, plaintiffs win in 48% of cases. But where the plaintiff goes to trial on only the issue of liability, plaintiffs are winning in only 21% of cases. So if you have tried to avoid the day of reckoning and coming to grips with your economic losses by agreeing in advance to a reference on damages, look what you've done for your client. You have diminished his chances of winning from 48% to 21%. And of course, you've increased his costs of litigation at least twofold. So start the judge thinking from very early on that this is a case of what if and but for. Another little tip is to extend the scope of the promised performance. Characterize the contract as broadly as possible. And this is because, as you know, contract damages are intended to put the plaintiff into the position that he or she would have been in had the performance gone as promised, had the contract been performed as it should have been. So what you want to try to do is to think, what was promised to the plaintiff? What was the plaintiff's reasonable expectation from performance? And how do I value the promised performance? And just as Barenblatt and Rosen devote a good deal of their book to the torts cases, the personal injury cases in quantifying economic losses, you may be able to borrow some ideas from the torts bar. Because torts lawyers, personal injury lawyers, are very used to dealing with probabilities, for example, and future events. And whereas liability, who caused the accident, was the light red or green, is decided 51% certain. Will the widow in a fatal accidents case remarry is not at all as certain. And so they are used to having judges think in terms of 20% chance, for example. But on the subject matter of the contract, some types of contracts deal with the issue of feelings more clearly than others. In Mr. Lenzner's paper, has he already spoken? Alan Lenzner quotes in his paper the Addis and the Gramophone case in which the courts held that there's no contract damages for hurt feelings. And he shows you a lot of exceptions to that kind of case, and I think that the exceptions are going to swallow up the rule very soon. Take the kind of case of Jarvis and Swan's Tour, where what is being sold is a holiday. The plaintiff is not really recompensed if he gets the cost of his holiday back. What you want to make clear, as the plaintiff's counsel did in that case, is that the plaintiff bought good feelings. He bought a Swiss or Austrian, I can't remember, holiday to a Gemütlichkeit inn where there was going to be a roaring fire and all sorts of congenial people sitting around and a yodeler and Viennese pastries, and instead he got some dry crackers and an empty inn and some sort of sour innkeeper and a yodeler who couldn't carry a tune, and I think was the innkeeper's wife to boot. Clearly he went back to London more stressed out, more full of hurt feelings than when he left to go to wherever Swan's Tour had sent him. So that contract was for the sale of good feelings. Other examples where what you're buying or selling are feelings is the case of the elderly couple who entrusted their darling pets to the mercies of Canadian Pacific Airlines, Judge Boren's case of Newell and Canadian Pacific. And the airlines killed one of the dogs and injured the other. It was foreseeable that those old people whose own emotional well-being and physical well-being depended on the well-being of their pets would be claiming for anguish and hurt and fear and disappointment and so on. And Judge Borens had little trouble in finding that the Swan's Tour line of cases was part of the law of Ontario as well. Now, we as lawyers will have to be careful of the kind of English case cited in my paper, where what the court found was being sold there was the protection of the plaintiff's feelings. The plaintiff had been bothered by a male, and she hired a firm of lawyers to protect her from the harassment. They got an injunction, all right, as they should have, but they failed to enforce it properly. And so the male individual molested the female plaintiff. And the English court had no trouble in finding that what they had been retained to do was to protect her well-being and her peace of mind. And instead what they had done was to harm it. And so she had little problem in getting damages for her increased mental distress. I point out in my paper that I think that the employment contract wrongful dismissal is going to be a growth area in this type of broadening the scope of promised performance. The traditional cases on employment law is that the master buys the servant's services for $1 fee. And if the servant is improperly terminated, then he gets the lost income that he should have got. But I give you the example of interviews for articling students or young lawyers in a law firm, and everyone in this room has sat on one side of that table or the other fairly recently, I would imagine. Think back then to how little talk there is about what is promised to you in terms of salary. In all the firms that I've worked for, and I've been through a few, that part of the conversation is usually brushed off with some reference to the going rate. And instead, both employer and prospective employee deal a lot with the collegiality of the firm, the intellectual stimulation of the job, the status of working with senior counsel on big briefs, that sort of thing. So that if you and your young lawyer are dealing with that kind of issue, that's sort of part of the job description, and it's entirely reasonable to suppose that if, in this time of recession, high overhead for law firms and the need to cut your overhead by firing some of these young lawyers, if you do that sort of thing, it's going to be, I think, quite predictable that the courts will find that you have insulted the employee's self-esteem or damaged his reputation. Another tip that I provide to you is to see whether the law on valuing a chance is of any use. In commercial litigation, take the land contract. Very often you'll have a contract which is subject to a condition precedent, like subdivision approval. If it's a true condition precedent, and that one is, then it will be dependent on the will of a third party, the Committee of Adjustment, say. If the subdivision approval is not granted within the time frame of the contract, through no fault of either party, then the contract's at an end. But it often happens that one party will repudiate before the time fixed for performance, or the party primarily responsible for ensuring the fulfillment of the condition will drag its feet and will not use its best efforts. Then the court is again in this what-if situation. An example of that is a case I cited earlier, which is mentioned in my paper in a couple of places, and that is the multi-malls case. The condition in multi-malls was that Tex Mall's site, which was being sold to multi-malls, be approved within a specified time for use as a shopping center. Now, it was by no means a dead cert that it would ever get that approval. In fact, the trial judge held that it was a less than 50% chance. So remember, you may be out of court if you haven't incorporated into your thinking this valuing of the chance concept, because you're going to be out on the balance of probabilities if there's less than a 50% chance. Unless you remember the law school cases about chances and start to think in terms of the personal injury probabilities and lead the judge through that kind of thinking. In multi-malls, what the defendant, the wrongdoing defendant, did was to make the chance impossible by going out and buying a neighboring land site and developing it as a shopping center. Once they did that, there was no chance that the Tex Mall site would be approved. So the judge had to think, if multi-malls hadn't done that, what would I assess the chances at? The judge went through all the contingencies. He found 5 of them. For example, the planning board might have considered that a shopping center in that region was premature, no matter the site. Or the planning board might have approved another site altogether. Or a third party, not the parties in the litigation, might have bought the second site and developed it in competition with Tex Malls. He found 5 contingencies, and not purely by coincidence, he rated the value of the chance as 20%, 1 in 5 of the damages otherwise to be assessed. The greater the contingencies, the lower the value of the chance. I just had an unsuccessful war story in which, on similar facts to multi-malls, the trial judge assessed the chances against my client of 50%. I thought there were a lot of contingencies, and I had led a lot of, I thought, evidence to show that it was highly unlikely that subdivision approval would be obtained, but the judge leaped to the 50% chance and awarded damages at that rate rather than the much lower rate that I would have hoped. Now, I was somewhat helped in that case. It's East Walsh and Anatel, by the way. It's cited in my paper. It's been reported, and there's already been an article in the National Real Property Law Reports about it. All my losing cases seem to get written up by somebody or other. I was helped in that case by the issue of specific performance versus damages and mitigation, and the issue of time for calculation of damages. And those are 2 topics also dealt with in my paper, and they're related. That is, when you're dealing with a land contract or a contract for something unique, shares perhaps, you have to consider whether you want specific performance and you're going to hang tough on that, or whether you really could find damages to be an adequate remedy, in which case you better get out and mitigate. Time of calculation of damages is related for the following reason. In the traditional case, damages are assessed at the date of breach. In some cases, particularly land cases, where specific performance would otherwise have been awarded, but for some reason isn't appropriate, damages will be assessed at the time of trial. And if specific performance is sought but should not have been, then damages may be assessed at the time when the plaintiff ought to, but failed to mitigate. So if you are plaintiff, or if you are defendant, in any fact situation like the cases that I discuss in my paper, you should be leading evidence of damage at 3 times: breach, mitigation, and trial. In the multi-malls case, a very informative case, you see how many times I'm relying upon it. One party led evidence of the value of the land at the date when mitigation should have, when the parties should have mitigated. The other party led evidence of the value of the land at the date of trial. Perversely, The trial judge found that the appropriate time in that case was the date of the breach, and neither party had given him any help. So what did he do? He weaseled out of it because he felt specific performance was the appropriate remedy, but he would have weaseled out of it even further by ordering a reference as to damages because of the failure of both counsel to pick the right date. So don't get caught in that situation. How am I doing time-wise? Is it about time? Well, let me just say a couple of words on the last few topics. The loss of capital and loss of profits tip is to be very sensitive to judges' concerns about double recovery. And those kinds of cases where your client has bought an income-generating piece of equipment in order to make more money, but the equipment has failed and has cost him money instead, those kinds of cases give rise to those concerns in judges' minds. One of the foundation cases of this erroneous understanding of the debate between the lost capital the plaintiff has put into his supposedly income-generating equipment and the loss of profits that he suffers is the case of British Rima, which is discussed and cited in my paper, and two Ontario cases which I mentioned earlier, the McLean and Vickers and Friedoff and Palmolift case. The Friedoff and Palmolift case, the fellow bought a ski lift, the Palmolift, which should have made his Ontario resort the Aspen of the North, and instead caused him to lose his shirt. The IDB foreclosed, and that was the end of that. You will have to educate the judge that you can get back the cost of the Palmolift and the cost of the profits that the Palmolift was designed to generate if you start educating him properly and educating yourself as well. Those kinds of cases have generated a lot of criticism, and articles criticizing them are cited in my paper. So I won't go into it now, but there is ammunition to make the judge see that it's not an either-or situation. If everything had gone as it should, what if, but for, then your client as plaintiff would have his ski lift and his land and the profits. And there's not necessarily a double recovery. A portion of my paper is designed to get you into the debate as to the proper method of evaluating business loss for the destruction of the enterprise versus an interruption. There are basically two methods on the business loss. One is frowned on by the Court of Appeal, and one has been blessed. I'm not sure that that debate is ended yet, and you might consider whether you can distinguish Dunlop and Lister in the Court of Appeal from the case that you want to present to the court. In the Dunlop and Lister case, the judge copped out and ordered a reference to the master, and the master valued the business on the basis that he found a predictable stream of income, $500,000 a year was reasonable. He found that that could go on forever because, after all, a corporation never dies. He found out that the after-tax profit on $500,000 per annum is $50,000, and he felt he should cut off the infinity damages at something he thought was reasonable, so he cut it off at 30 years. He multiplied $50,000 after-tax income by 30 years, and then he gave a present value for the $1.5 million of $900,000. Not bad, even in Toronto, Mr. Peroy, and $900,000 as a judgment is not bad, considering that Mr. Lister hadn't been in business for years. Court of Appeal said, no, that won't do. First of all, you're too generous to the plaintiff. Second of all, you're too arbitrary. Why 30 years? Why not 15 or 45? And lastly, you haven't taken account of the contingencies. So the appropriate method that Dunlop and Lister in the Court of Appeal applied is to treat the business at the moment of destruction as though it's a capital asset with a fair market value as a going concern. What you do, you use the same $500,000 stream of income, you use the same $50,000 profit, after-tax profit, and you capitalize that $50,000 by a multiple that takes account of the contingency. How do you do that? Well, you take a risk-free investment like Canada Savings Bonds, which are paying, say, 10%, and you figure out how much more risky was Mr. Lister's enterprise or your clients compared to Canada Savings Bonds, until you come up with a multiple of, say, 8% or whatever it is. And that award will always be less than the generous Master's Award. But I don't think that we've heard the last of the two methods at all. And in the back of Baron Blood and Rosen, you can see how these kinds of scenarios can be applied to your case. And very last of all, in my paper, I give you the, I was going to say comic relief, but I won't. I mean, it's not appropriate. The situation of, again, the torts lawyers and the jury lawyers, like those in my firm who do a lot of defamation work. My partners, Porter and Potts, have a whole section in their textbook on defamation about tips to watch for to maximize damage awards before juries in libel actions. Some of them you may not have thought of at all, and a surprising number of them may be inspirational and useful to you in commercial litigation as well. So I suggest you consult the list, many of which tips are included in my paper, to see whether we can use them to instruct and titillate and persuade judges in commercial litigation, as well as those performers before juries do in their field. Thank you.
Thank you, Joyce. I think that depending on our particular neurosis, we can all be either terrified or delighted by the authority that Joyce brings to our attention at page 11 of her paper. It can be a new growth industry, and the concept of suing lawyers who get the judgment they want and then don't enforce it as well as they might. For our next speaker, we have looked to somebody again to provide the nuts and bolts, the practicalities of maximizing our damage awards. We've been told continuously of the importance of the expert witness. We aren't always told about where to find them, how many we can have, how we phrase that all-important hypothetical question. In the person of Dave Bristow, we found somebody to whom we can look with authority for those answers. David is with Fraser Beatty. He is best known, as was his much beloved father, for his knowledge of construction liens. His practice and his expertise is much broader than that and extends into all areas of commercial law. And it is with great pleasure that I introduce you to David Bristow.